The North Carolina Supreme Court is clearing the way for a trial surrounding the death of a Highway Patrol intern. Lisa Higgins says her son Michael was a senior at East Carolina University when he was completing an internship with Highway Patrol. He died in August 2020 while riding in a patrol vehicle. That vehicle reached speeds of 113 miles per hour before crashing.
Joining us again this morning, our chief legal analyst, Khalif Rhodes. Khalif, we'll get to some of what could be in this trial coming up here in a second, but why did they decline to hear the appeal? What does that tell you? What's going on here?
Well, the court was only going to grant a cert, like if this was the Supreme Court or North Carolina court is in the same scenario. They're not going to grant an audience and the ability to hear a case if there's not a final resolution, first of all. So they're asking for it to be done on an emergency type of basis. This case was filed in Pitt County. The judge there dismissed the case, right? The family, the mother specifically, has been pushing for this case and takes it to the Court of Appeals. Judge Earl Wood from Mecklenburg County sat on that panel and decided it was a 2-1 decision that they have the right to go to trial. So it was forced to go back to Pitt County. Well, in between that time, there was a settlement offer. They rejected that. But then also the trooper requested it to go to the Supreme Court. The Supreme Court doesn't have to jump into this case in that emergency basis. They can say, no, we'll allow this to be resolved in Pitt County, and then you'll have an opportunity to appeal, or we can grant this appeal right now. And they decided to not grant that appeal, which is something they would routinely do. It would have been extraordinary for them to do it the other way around.
So talking about this case in particular, normally in North Carolina, public officials can be shielded. They have certain levels of immunity, but then when does it go beyond that? It's the gross negligence
You're all over
right?
it.
Okay.
You've been paying attention in my law school class here. I appreciate it. So part of that, and Judge Dillon, who wrote the dissent for the court, said that, listen, North Carolina history wants to give and shield our officers with a protection of immunity, that officer immunity, even if they're doing something that's negligent. It crosses the line when it goes to gross negligence, and that's what the majority said in this opinion, that it crossed the line. And specifically, Judge Earl is saying that we shouldn't make the determination as judges if it crossed the line, because there's a question of material fact. That question of whether it was grossly negligent or not shouldn't be decided by me at all. It should ultimately be decided by a jury, by a trier of fact. And you have to look at the evidence in the light of the non-moving party. Well, who's moving for this to be dismissed? Defendant. Who's the non-moving party? It's plaintiff. So if you look at the facts in the light most favorable to the non-moving party, you would say that someone that is driving at 113 miles an hour in a 55-mile-an-hour zone, driving with one hand on the wheel, not following the proper protocol or policies or procedure that are in your manual, in the light most favorable in those scenarios, looking at it from the light of plaintiffs, it would seem like that would be gross negligence, enough for a jury to make that determination. And that's how we got there. And to give the definition, he wrote in here, look, the court has defined gross negligence as wanton conduct, right? Reckless disregard for the safety of others. And so Judge Dillon attempted to say, well, you need that wickedness, you need some intent, some malice, and that is part of the definition, but it also is manifesting a reckless indifference. That's not that I have the malice to harm you, but I was so reckless with my disregard for following the normal procedures that I've done something that I knew or should have known would have harmed you.
Quickly, what challenges do families have when you try to take on like a state trooper's office?
Well, it's the first thing that Annie said. It's that getting past officer immunity, any type of implied immunity, any type of immunity that protects them. And you want this immunity because they are on the front line. They are doing things that place them in the public harm to be subject to litigation on a daily basis. And we wouldn't be able to operate if you didn't have some type of immunity to protect them. So you need to have that. It's when you cross that line. So if you're someone that's in a scenario that you believe you have a claim, has it crossed the line of going to gross negligence? And an attorney will be able to walk you through that. Everyone's going to believe they have a case that could meet that standard. Most of them don't. And that's why they are dismissed on the court level like this case was in Pitt County. But what I can tell you is it's going back to Pitt County. It will be a trial. And at some point you will have a resolution that the wheels of justice have turned extremely slow. Remember, this case was from 2020. That's 6 years to get a trial date.
My gosh.
Well, we'll keep track of this one. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.